Well, good morning, everyone. Thanks for joining us today for this HIPAA training. I'm Grayce, the City Engagement Officer for the Personnel Department, and I'm supporting the tracking of the city's vaccine mandate. This training is for employees who are working with vaccine and testing data for the city employees. So it's an hour training, and we will be recording it. You will receive a completion certificate for your training records if you have registered and you logged onto the Zoom your account with your full name, and you stay here for the entire training. So we'll be entering your name and your EID into the applicable learning management system, which for most of you is Cornerstone, based on the records we have. So if we don't see your full name, we can't give you credit for the training. So we'll make sure there are instructions in the appointment about how to do that. You have all also received the full PowerPoint presentation in that appointment. So you can see we have a lot of material to get through. So if you have questions during the training, please go ahead and put them in the chat box and we'll address them at the end of the session. So my awesome team, Jessica Taylor and Jean Clark, and I will be supporting this training. So thank you to Jessica and Jean. And now I will turn this over to Deputy City Attorney Judith Thompson, who is the HIPAA expert for the City Attorney's Office. Thank you for being here today, Judith, and I'll let you take over.
Okay, thank you very much. Good morning, everybody. Again, as was said, my name is Judith Thompson. I'm from the City Attorney's Office, specifically the General Counsel Division, and I am the HIPAA specialist for the city. We're here to talk about HIPAA and also the CMIA, which is the California counterpart to HIPAA, which is the Confidentiality of Medical Information Act. Okay. And specifically, we're here because as HR and IT personnel, you will have access to COVID-19 vaccination records that are going to be held electronically on behalf of the city by an outside vendor. And for that reason, it's important that you know the proper way to handle this confidential information and to disclose it, to use it and disclose it under only the appropriate circumstance. So even though HIPAA is not directly applicable, as I will explain in this this training session, you will see that we're going to show you the best practices. In other words, we're going to follow HIPAA's dictates and suggestions in terms of handling confidential information. Okay, slide 2, please. All right, this slide is called Caveat and Takeaway. And basically, the caveat is that an employer, such as the City of Los Angeles, in this function of collecting vaccination data, and you as HR personnel in seeing that vaccination data and attesting to the fact that you've seen it and that the employee has in fact been vaccinated, that is an employment issue. So my discussion is not going to cover anything covered by Cal OSHA or anything covered by the ADA or other disability discrimination laws. For the questions concerning those laws and others, consult the Labor Relations Division of the City Attorney's Office, and there may be a training scheduled to cover those depending on the questions that come in. Also, the takeaway from this should be that you're going to apply HIPAA, privacy and security rules, and the California Confidentiality of Medical Information Act rules, and use them in terms of best practices in your dealings with this data. Okay, slide 3, please. Slides 3 through 9 basically are an outline of this training. And as I go through the training, I'm primarily going to highlight where you can find information on these topics in these slides. We have 126 slides. We're going to go through them in a little less than an hour. So I'm not going to go into specifics except for certain key areas. So If you're going to take any notes at all, make note of the page locations or the slide locations of this information so you can review it in the future and use it as a reference guide for yourself. Okay, so that's slide 3 through 9. Slide 10, please. Okay, what is HIPAA? Well, HIPAA stands for the Health Insurance Portability and Accountability Act. It has 4 sections: the privacy rule, the security rule, administrative simplification, and believe it or not, a bee has flown into my house. So I'm being a trooper today, but if I jerk, that's because there's a bee here. But we're gonna move forward with this. Okay, slide 11, please. Okay, I've created a pie chart here so you can see the topics that are covered by each section of HIPAA. Today, we're going to cover the privacy rule and the security rule. The administrative simplification rules primarily deal with codes, identifiers for healthcare providers and employers and health plans, and that's to facilitate billing of healthcare electronically. The enforcement rules I will touch on, but they really, as I've mentioned, don't apply because HIPAA is not directly applicable to this particular section. Although, I mean, I don't know if you know this, but the City of Los Angeles is a hybrid covered entity under HIPAA, but for its healthcare purposes. Okay, slide 12, please. All right, here's some more terms that you should be familiar with as we move forward in this discussion. Individually identifiable health information, or IIHI, protected health information, PHI, covered entity, hybrid entity, healthcare component, the concept of use, which is when a covered entity internally uses PHI, and disclosure, when a covered entity discloses or transmits PHI to an outside third party. The general rule under HIPAA is that a covered entity cannot use or disclose protected health information without authorization of the patient, in our case, authorization of the employee. But there are exceptions to that. One example of an exception is when a covered entity uses PHI for treatment, payment, and healthcare operations. It's called TPO. An example of an operational use would be for checking for compliance with the city ordinance requiring COVID-19 vaccinations for all employees unless there is an applicable exemption. That is an permitted use of PHI for operational purposes. Okay, next slide, please. Covered entity. A covered entity is a single entity like the City of Los Angeles. And what makes it covered under HIPAA is that it serves as either a healthcare provider, a health plan, or a healthcare clearinghouse. As I mentioned before, the City of Los Angeles is not a covered entity for purposes of collecting COVID-19 vaccination records and maintaining them to comply with a city ordinance or with the mayor's executive directive. However, portions of the city have been determined to be covered by HIPAA. For example, the fire department's EMS section, the correctional care section of the medical services division of the personnel department. Those sections of the city have been designated as what's called a healthcare component. And there are other components of the city that serve in support roles to those functions. They've also been designated. Okay, if your organization finds that it has HIPAA covered functions and then functions that are not covered by HIPAA, like say our library department, what that entity will do is declare itself a hybrid entity so that in the event of a federal audit, only the designated portions will be examined by the federal government. Okay, next slide, please. Okay, operational use. All right, these are in slides 14 and 15. These slides give examples from the HIPAA regulations of permissible operational uses of PHI that do not require authorization by the patient and / employee. Okay, slide 16, please. Slide 16 through 19 covers what a hybrid entity is. As I've already mentioned, a hybrid entity will, an entity will declare itself a hybrid entity when at least one of its subparts handles HIPAA, but there are other parts that do not. The parts that are covered by HIPAA or perform HIPAA functions are called healthcare components, or HCC. And these slides here tell you what the obligations of a hybrid entity are. Obviously not to disclose PHI and to create firewalls. And on this point, I'd like to mention that I have recommended the outside vendor that is going to be maintaining these vaccination records on behalf of the city to attempt to firewall or have a password access by department. So in other words, HR from a particular department, say the library department, they should only have access to the employees of that department, no other employees. And there's a doctrine under HIPAA that will explain that further. But additional rules include documentation of the designation and so forth. That's covered again in slides 16 through 19. Okay, slide 19, please. Okay, slide 19 gives you the history of designation in the city of Los Angeles, if you're interested. They were first declared a hybrid entity July 30th, 2010. And the latest activity happened in 2018 when the mayor's office was designated as an HCC, and DWP that was previously designated was de-designated because the healthcare service provided by their personnel department now focuses primarily on employment-related injuries, not just general health care. Okay, slide 20, please. All right, in this slide, this comes from a presentation I did in March of 2020 in Washington, DC with the Assistant Attorney General for Washington, DC. We were given a presentation at the HIPAA Summit explaining the application of HIPAA to the public sector. And so what you see here is a chart showing in peach all the currently designated portions of the city of Los Angeles. This city attorney's office serves as an advisor. The pink shows agencies or portions of the city that are actually performing business associate-like functions, and which may be de-designated and converted into internal business associates. I will explain all those terms later. But there's one section that's in yellow. That's a best practices component. The LAPD has a behavioral science section. They treat their records as if they're covered by HIPAA, but they are not. They're not because there's no bill that's generated based upon the services provided. Okay, next slide, please. All right, this is the District of Columbia's approach. As you can see, they have a lot more sections that are covered by HIPAA than we do. This model is probably closer to what LA County uses because this jurisdiction is in charge of their school district. They have hospitals, they have clinics, and they have a lot more involved system than we do here at the city. We don't run a school district. We don't have any hospitals and clinics per se at all. And so the scope of our healthcare practitioner service is really limited to the EMS service that the fire department provides, and the services provided by nurses and doctors in the correctional care section of the medical services division of the personnel department. Okay, slide 24, please. All right, this chart is here to explain basically how we get to PHI. We start with health information, and I'm going to go through that official definition. And then a subset of health information is individually identifiable health information, which is pretty much self-explanatory. And then we get to PHI, which is actually what is covered by HIPAA and the CMIA. Okay, slide 25, please. Okay, health information means information, whether oral or recorded in any form or medium, that is created or received by a covered entity being a healthcare provider, a health plan, or healthcare clearinghouse. Slide 26, please. And it relates to the past, present, or future physical or mental health condition of any individual, the provision of health care to an individual. An example of that is a COVID-19 vaccination. That's a provision of health care, or the past, present, or future payment for the provision of health care. So in other words, the bill. That's a definition of health information. Okay, slide 27, please. Individually identifiable health information is basically what it says. Health information that can be, that identifies an individual, or there's a reasonable basis to believe that the information can be used to identify the person. This is a subset of health information. Next slide, slide 28, please. Okay, protected health information, or PHI. That is individually identifiable health information that is transmitted by electronic media, or it's ePHI. It's maintained in electronic form, also ePHI, or it's transmitted and maintained in any other form or medium, PHI. The privacy rules covers PHI in any medium, while the security rule covers PHI or ePHI in its electronic form. Okay, slide 28, please. Okay, this is important for us. Protected health information does not include education records. It also does not include employment records. So your workers' comp files, even though they contain health information, and hopefully that health information is being treated as confidential and is held separate, or has some kind of extra level of security to it. In general, workers' comp records are not covered by HIPAA. Also, sick leave records are not covered by HIPAA. And mandated employer-created vaccination records are not covered by HIPAA. This is why this presentation for HIPAA rules is being presented to you as a best practices presentation. Okay, slide 30, please. Okay, now we're on to the privacy rule. It's also known as the standards for privacy of individually identifiable health information. Slides 30 through 71 cover the privacy rule. And again, I'm going to reiterate the privacy rule. The general rule is that HIPAA prohibits a covered entity from using or disclosing PHI without authorization from the patient or the employee. Okay, so can we go to slide 31? Okay, just for your information, I included in here an explanation as to what a HIPAA authorization should look like. So if there's ever a request from an outside third party, or from an, from an outside third party for the COVID-19 information that you have, and which is, it's identifiable, and it has the a provision of healthcare reflected in it, along with dates and other things. So it definitely is PHI. These are the things contained in slide 31 and several slides moving forward that must be present in that authorization in order for it to be a valid authorization under HIPAA. You can't just use a generic authorization for release of information that is characterized as PHI. You must use a HIPAA authorization. Okay, slide 35, please. Okay, so slide 31 through 34 covers authorizations. Now we're on slide number 35. This talks about the exceptions to the general rule. In other words, these are disclosures that can be made without an authorization. And there's 16 categories here. I'm not going to go through all of them. We're in this 41 slide segment here. We're only going to land on 7 of these. One of them is this slide, which talks about employers. The first point is that if a healthcare provider has cared for an employee and we're seeking information from that healthcare provider, the healthcare provider may only disclose the minimum necessary PHI to the employer concerning a member of the employer's workforce with a valid authorization. So an authorization meeting the elements that that are included in this slide presentation. So you have those materials that you can always check against to see whether or not the authorization is sufficient to allow you to release the information. But now the next point, required by law. When required by law, disclosure of PHI is permitted without authorization. Now this is talking about HR and IT folks. This talks about what you can do, not the healthcare provider. You can release it when it's required by CalOSHA, by public health reporting, by workers' compensation subpoena, and the citations below reflect both the federal and the state law. And by the way, CFR stands for Code of Federal Regulations. Those are the sections, and the comparable section under city law, California law is in the civil code. Okay. The next, okay. Also included in this segment here are exceptions for fundraising, health oversight agency, judicial proceedings, like if you receive a subpoena, how to handle it, law enforcement, if a member of law enforcement wants any of these PHI or medical records, it depends on whether or not the person is classified as a victim, a suspect, or a witness. Those rules are also in this section. The prohibition against marketing and an opportunity to agree or object, and something that definitely doesn't apply to city organ procurement. There's rules on that. Okay, can we go to slide 57, please? Oh, excuse me, I'm skipping one. I'm sorry. Slide 50, I'm sorry. Okay, this is the other exception that I thought important to raise based upon what you're doing in connection with this vaccination data. Under the public health activities exception, a covered entity must disclose PHI to a public health authority without a patient's authorization when required by law. A covered entity may disclose PHI to a public health authority without a patient's authorization if limited to the following: reporting of a disease or injury, reporting vital events, surveillance, And any disclosures for public health purposes must be limited to the minimum necessary for that purpose. I think the one that applies most here is the small I, reporting of disease or injury. If you are requested, obviously, by the county health department, state health department to disclose information, you don't have to give it in aggregate form. In other words, giving raw numbers of employees who have tested or not tested, but who've been vaccinated, and those who have declined, and what their stated exemption is. That would be in just raw numbers. That would be an aggregate form of disclosing information. You're not disclosing PHI because there's nothing individually identifiable to any person. However, under this exception, you can release PHI. It's a public health authority, and it's for purposes of reporting of a disease. So it's authorized under HIPAA to disclose it. Okay, now slide 57. Okay, if you receive a request, I'm trying to think, a Public Record Act request. Suppose a press organization requests information that basically would have you reveal some of the data that we have concerning our employees and their vaccination status. HIPAA gives 3 ways to de-identify data so that it is no longer PHI. You can hire an expert and follow the rules in that column. You can do what's called the safe harbor approach. That means we're removing 18 identifiers from the data. And generally, once you remove all of that and remove the medical information, there's really no information to give. The last one, limited data set, where only 16 identifiers are removed. That's generally done for research purposes. Like if someone from USC or UCLA who's working on a doctorate or some research project wants data on our vaccination status or testing or symptoms or anything of that nature. That's a list of the identifiers that would have to be removed before it could be released. Okay, slide 58, please. Okay, another category of exception is clumped under what's called specialized government functions. I'm not going to go through all of them here, but those are on slides 58 and 59. And they range from anything from the correctional institutions exception that allows certain correctional employees to have access when it is for purposes of safety of those employees and other inmates, all the way to protective services for the President of the United States. Okay, so there's a wide variety of situations there. Okay, can we go to slide 65, please? Okay, slide 65 is discussing the 14th of the 16th use and disclosure exceptions. It's for treatment, payment, and healthcare operations, or TPO. We've already touched on this, but in this portion of the presentation, the slides, you have a little more information. I give a little more information about what is considered treatment and what would be considered a payment circumstance, and also go into different examples of healthcare operations. Just remember that when a covered entity is engaging in TPO activity, an authorization of the patient is not required. Okay, could I have slide number 72, please? All right, this is the doctrine of minimal necessity. This is slide 72. And generally, when PHI is requested user disclosed, only PHI which is relevant and necessary to accomplish the intended purpose of the user disclosure may be used or disclosed. Okay, and I cite the sections, including the California Constitution, Article 1, Section 1, meaning the right to privacy. So if there's been a specific request for John Doe's in the, I'll just say the library department's vaccination status, and it is, say it's from the health department, you don't need to give any more information than what is being requested in that request, because John Doe does have a right to privacy. So you don't need to, you shouldn't give his social security number and any other personal information that's not relevant to the intended purpose, which is basically that public health agency just determining whether or not John Doe has received the vaccination. Okay. Then this also covers the covered entities' responsibilities and areas that are exempt from the minimal necessity doctrine, like a healthcare provider. A healthcare provider can make inquiries and can share information because oftentimes they have to consult. They have to be able to consult very quickly with other specialists and with other healthcare providers, the theory being that they're on the same healthcare team. And so while eventually other doctors who were involved in the care of someone will eventually get an authorization signed by that patient for immediate emergency attention, the doctrine of minimum necessity is not applied to healthcare providers. Okay, that's just an example. Okay, slide 73, please. Okay, this talks about the concept of incidental disclosures. The gist of this rule is that at all possible, you must use due diligence to try to avoid incidental disclosures. You don't want, if you're discussing the health status of anyone in any context, it should be in an environment where you have a reasonable expectation of privacy, that others cannot overhear you. They understand the drafters of HIPAA that say when a paramedic is out on the street and he's working as a team with another person and they're working on someone and they're having to talk to each other, the passersby who happen to hear what they're saying, that does not involve a HIPAA violation. That's considered an incidental disclosure. But this rule emphasizes the importance of trying to avoid those incidental disclosures whenever possible. So in your context, HR and IT, that means that if you are the person charged with responsibility of checking or inputting any of this data, are you in a private office or are you in a cubicle where the entrance to the cubicle from that entrance, you can see your screen? You need a screen protector on your computer's monitor. If you work in a pool area where you share a working space with others and those others are not assigned to the same duties that you are assigned to, there should be screen protectors on there. That is to avoid incidental disclosures and also to follow the doctrine of minimum necessity. Okay, now slide 81, please. All right, now we're to the security rule. We've covered the privacy rule. This is the other second part of the HIPAA rule. And so this IT folks should pay particular attention to this. And you may note that a lot of the rules in this section are things that you already deal with in the area of computer security and data security. A lot of these standards are very commonplace for the industry. And let's see, and it outlines the minimum administrative, technical, and physical safeguards required to prevent unauthorized access to health information. Okay, slide 82, please. All right, now these slides that have these graphics, slides 82 through 84, they show the required security rule policies. They're divided by functions. So in other words, as I've already mentioned, administrative, physical, or technical. Those are the three aspects of the security rule. They're required, and you may notice a number in parentheses. Those numbers are the actual numbers from the City of Los Angeles HIPAA Privacy and Procedures Policy Manual. And so those are the actual policies pulled from that manual and organized by whether or not they're required or whether or not they're merely addressable. And also by category, if it's administrative, physical, or technical. Those again are slides 82 through 84. Can we go to slide 85? So we're skipping those three slides, and now in slides 85 through 89, what I've done here is I've listed these policies by number and by name. And also I indicate in red whether or not they're required. These are all the required policies in this section. And what section, what type of policy? Is it administrative? Is it go to physical aspects of handling data or and so forth. And so this is a nice way to organize it. However, some of you may want more detail. If anyone wants a copy of the city's HIPAA privacy and procedure or policy and procedure manual, it should be on the city's website, but if not, you can email me. My email address will be at the end, and I can make sure that you get a copy of it. Okay, so we're going to go to the next slide, slide 90, please. Okay, slides 90 through 92 talk about the addressable security policies, organized the same way by administrative, physical, and technical category. These are addressable. In other words, if your organization is trying to become HIPAA compliant, what you want to do is you want to address the required ones, obviously, first. Addressable doesn't mean you can ignore them or that they're optional. They still are important and should be followed. However, they have less of a priority than the required ones. And those are, again, covered in slides 90 through 92. Can we go to slide 93, please? Okay, again, what I do here is I give a brief synopsis of what each policy involves by policy number and by title. And again, if anyone wants a copy of the entire city policy for HIPAA, just contact me if you can't locate it on the city's website. We can work out the logistics of that. Okay. All right. And this brief explanation is slides 93 through 100. Okay. May I have slide 101, please? All right, this is the administrative simplification. This is a third of the 4 parts of HIPAA. I'm really going to go into this because it deals with billing. It sets up transaction codes and identifiers for providers, for entities, for healthcare providers, for employers, and it also has codes for the actual service, like whether or not the person received chemotherapy or an injection of what drug. It's all very highly technical, and it's done that way so that when a transaction occurs electronically, the patient will have the utmost of privacy because it's not stated in plain English, it's all in code. Okay, let's go to slide 105. All right, slide 105 is under what we call administrative standards. And one of the things I didn't mention in the administrative simplification, you don't have to move the slide, I'll just say this. Administrative simplification, it not only handles codes and identifiers, but it discusses HIPAA policy and procedures and the importance of having that, and also talks about the importance of HIPAA training. And those are slides 101 through 104. Okay, so now we're on 105. This talks about HIPAA penalties and enforcement. And on this and the sanctions, there's both civil monetary sanctions, and they're criminal monetary and criminal consequences that can lead to jail time for violating HIPAA based upon the level of culpability. Those levels are explained on this slide here. So obviously the more egregious, the more culpable your intent, like in other words, if you worked at a hospital that a lot of celebrities go to, and you get a medical record of a celebrity and you sell it to TMZ or something, the hospital and the individual are going to face consequences for that. And that individual will probably see some jail time. So HIPAA is very serious. Could you flip to the slide 106, please? Okay, these are the civil monetary penalties. As you can see, they can start as low as 100 and go as high as 1.5 million, depending on the severity of the violation and the number of people involved or impacted by the act. Could you go to slide 107, please? Okay, here are criminal penalties. I outline here who can be held accountable for criminal penalties, who can be prosecuted for our HIPAA violation. Could I have the very next slide, please? Okay, the criminal penalties also not only can be jail time, but monetary violations, up to 50,000 for a known violation with false pretenses up to 100,000, and a known violation with intent to sell or transfer up to $250,000 and or up to 10 years in prison. So that shows you this is very serious law and should be taken seriously. However, for purposes of this training, I will again reiterate, this is a best practices training. We are looking at the standards for HIPAA, and we're going to look to apply them because they are the best practices for handling this type of sensitive data. Okay, slide 111, please. Okay, administrative standards. Now we're talking about business associates and business associate agreements. And slides 111 through 116 gives the definitions, the responsibilities, and it also of a business associate. And it also tells you what a business associate agreement must contain in order to be permissible under HIPAA. Okay, so I will leave that to you to read at your leisure, but that's at slides 111 to 116. Slide 117, please. Slide 117 through slide 121 covers the duties and responsibilities of a HIPAA privacy officer and a HIPAA security officer. Just a point of example, the fire department has both. Because of the volume of PHI they generate every day in their EMS function. I'm not going to go through the duties here, but they're explained in those slides. Okay, slide 122, please. Slide 122, notice of privacy practices. This is a notice that is given to a patient after the performance of a healthcare function. And it just generally puts the patient on notice as to what could possibly happen with their health information. If it's going to be disclosed for research or some other function, the patient needs to be informed that up front. For purposes of this COVID vaccination function, though, we don't have to worry about that because the healthcare provider was the entity that put the shot in the employee's arm, not the city of Los Angeles. So we don't have to worry about notice of privacy practices, but I'm just making you aware that's part of the HIPAA compliance system. Okay, slide 123, please. Okay, this slides 123 through 126 talk about patients, or in our case, employees' right to access records. As a general rule, a patient has a right to inspect, review, and obtain a copy of their health information held by a covered entity, a business associate, and hybrid entities. And slides 123 through 126 give an explanation of those rights and the responsibility of the covered entity and the business associate to comply with that right. Okay, slide 127, please. Okay, we're at the conclusion of this training. I would really appreciate it if you feel that this presentation and the materials that you're going to look at later that have been provided to you are helpful to you. Please let Dave Michelson know. I have his email address here, david.michelson@lacity.org. And could you CC me? Judith.thompson@lacity.org. You can also forward any questions that you have to that address as well. Thank you very much.
Thank you, Judy. So we did get some questions, and then folks, if you could check your chats, Jean has been sending messages to folks where we only have like a name, like an unclear name. So make sure that you respond to her to ensure that you get credit for this training. So we did have some questions, Judy. One you mentioned already, the city's HIPAA policy manual, which you mentioned that if folks wanted, they could email you. I think what might be easier, just to not overwhelm your email box, we'll get it and then we'll send it out to everybody. There was also a question about some slides being missing, some information from what the attachment they got. So we'll resend the attachment as well to let folks get all that information. We did have another question. If you could please clarify your comments regarding slide 29. Are you saying that the city's employee vaccination records are not PHI, but you are recommending that the city treat it as PHI as a best practice?
Okay, let me clarify it. This is my interpretation of the rule, because if you go back to the slide that talks about PHI, PHI is something that is either provided to a health a covered entity, or it is created by a covered entity. And covered entity would be a healthcare provider. So my interpretation is the actual COVID-19 vaccination card that everyone gets when they receive a vaccination, that is PHI. That is not employer created. That is a PHI document. But if an employer has an employee just hold a card up to a screen, or hold a card up to an HR employee and says, see, I did have a shot, it shows the dates, and here's my name, and here's my ID to show that this is me. Okay, and then that HR employee goes and creates a record that, yes, Judy Thompson showed me her vaccination record and she has received the vaccination. Okay, I am viewing the latter as an employment record. I mean, I'm viewing the former, the vaccination card, as a PHI medical record. And now, what is the distinction here, and why are we doing HIPAA if the vaccination, the attesting to seeing it is not PHI? Well, it's referring to a document that is PHI, and to the extent that this is a sensitive area, and to a large part, a lot of it is uncharted. We're dealing with issues in forms that we haven't quite dealt with before. So as a, to err on the side of caution, if there's error happening here, I am recommending that this be viewed as a record that is held by and being handled by entities that are not covered by HIPAA for purposes of this vaccination. As I mentioned before, the fire department is covered because of their EMS, and a portion of the personnel department is covered because there's doctors and nurses treating people who are inmates in city jail. That's clearly under HIPAA, and anything that's generated from those activities is going to be relating to those patients is going to be covered by HIPAA. But what I'm referring to is our employees. We have a city ordinance that mandates that employees be vaccinated. We have a mayor's executive directive that is mandating that that the record of vaccination be collected from the employees. So by HR attesting that they have seen the record. So those are employer created vaccination records. And typically they are excluded from the typical definition of PHI. However, again, to the extent that your outside vendor that is holding this electronically has medical information generated from a healthcare provider, i.e. the person who gave them the vaccination, or any other circumstances beyond what I can contemplate at the moment. This approach, I think, keeps the city covered, keeps us in compliance, because we're handling it with the same care and confidentiality that that we should handle medical information. And so that's, if that is confusing, I apologize. But like I said, a lot of this is uncharted territory. I don't know that we've had a pandemic before. So, and we're trying to deal with it as best we can. And we want to keep not only the employees and the public safe, we want to be as in close compliance as we can, being realistic with the circumstances. The Federal Department of Health and Human Services Office of Civil Rights has issued several edicts saying that for purposes of or under this COVID-19 emergency, a lot of their enforcement rules are being laxed. They're not in enforcing every little item, knowing that, say, when people are in a long line and they're getting vaccinated and the person administering the vaccination is asking to see their ID and is saying their name out loud, it's within earshot of other people, you know, HIPAA is not going to be perfect under these circumstances, but they understand that it is important to the extent we can to try to keep it as confidential and safe as possible.
Thanks, Judith. And then a lot of the folks on this call will also be handling the medical or religious exemption forms in regards to those forms, and like the medical one will have a doctor's note attached to it. Well, it's actually the doctor will have to complete part of it. If they're handling these forms, you would also consider them to be under employment records, right? Under this situation.
Yes, they're producing that in compliance with the city ordinance and with the mayor's executive directive. However, well, no, not however, that so it carries the same weight as the COVID vaccination card. And so it should be handled with care. And I'm going to emphasize again, HR in your individual departments, your discussions, you need to be mindful of where you are, and avoid using individuals' names when you're discussing different issues if possible. If not, go in closed offices. This should be very private because we don't want to create a situation where anyone could potentially be stigmatized. Oh, I have a vaccination, but they don't. I understand that all city employees will have to wear a mask, so there won't be anything visible distinguishing a vaccinated versus an unvaccinated person for whatever reason. Everyone will wear a mask. So it's up to HR in handling this information and doing your job to record keep and make sure that we have accurate records for all the employees, that information that shouldn't get out, in other words, is not minimally necessary, is kept very protected.
We had another question come in. If an employee is coming to my cubicle to show me their card and all I'm doing is recording in the designated program, should I try to set this up in an office instead for privacy?
Yes, that would be my recommendation.
Okay, great. I think that's the extent of the questions that we have. And so we have a few minutes. There are folks that are sending files back and forth, and we've, asked them if they were going to do that, who's vaccinated, who's unvaccinated, that they password protect that information and make it as secure as possible. And if possible, don't send it via email. If we can do it a different way. I'm assuming that is something that you would recommend as well, Judy.
Well, let's see. Ideally, like I really raced through the security rules. One of the addressable policies is encryption. Yeah. I don't know to what extent the email can be encrypted. If you can piggyback off of I know the fire department now has its own standalone encrypted email system so that they can send PHI over emails. If you're talking about an email where you're discussing something versus an email where there's an attachment that is in fact PHI, yeah, then I would I'd have a conversation with me. I would just want a little more information. I don't know that I want to give a blanket yes or no to that. Or even, interestingly enough, faxing, because it can't be hacked, is an acceptable way of transmitting PHI. Yeah. Now, I would think to add to the security, call the person you're sending it to and say, stand by the fax machine, something is coming that you need to pick up right away. You don't want to just laying there. Yeah. But faxing is an acceptable mode of transmitting PHI. Great. If you don't have encrypted email.
Thank you, Judy. I think it'll be harder to find a fax machine now than
anything else,
but anyhow. Well, we are at time. Thank you again so much, Judy. Really appreciate your time and your efforts. And thank you to everyone who joined in. If you have any other questions in the chat that we didn't get to, we'll follow up. Or you can email Judy. Her email's up right now. And so thank you again, everyone. Have a great day.
Thank you.
Thanks. Bye.